Sure. Do you want to do the intros, Francine, or would you like me to?
You can do it.
Okay, the shortest gets picked to do the intros. I'm Heather Rafter, and this is Francine Godrich and Philipp Lengeling, and we are lawyers. And we are also, two of us are solicitors, licensed here in the UK. I'm also licensed in California. Philipp was trained in Germany and licensed in New York. So we can kind of cover geographic questions as well. And so we are here. Let's do a little bit of an overview about topics that you might be interested in, and then we can have a show of hands and see which ones you'd like us to talk about, and we'll take questions. And we're going to go fast because we have 20 minutes. All right.
Yes, I can. Does this work? Hello.
So Francine works for Focusrite, I should say. So she's in-house, and Philipp and I work for a law firm called RafterMarsh. And all of you are fairly young, but if any of you know DigiDesign, I was the general counsel of that company when there was a DigiDesign. Okay, so a lot of times clients seek to retain us to provide legal services. About 60% of our clients are in the audio industry, and of course, Francine works for Focusrite. And these are the topics that we get asked about a lot. So this is our audit checklist. If we take in a new client, we're like, oh, here are the services you might be interested in, and sort of specific to companies generally, but we found that these are really relevant also to audio companies, for example, map policy, right? So we can talk about any of these. And if you want slides, just give us your information and we'll send them, but this is pretty it. So the manufacturing topics, this is pretty audio specific. Should we do Q&A, or do you want us to quickly tell you what like the 5 biggest mistakes our audio companies make?
I think before.
That would be great. all the secrets of all of our clients. No, one of the questions that I actually had, it would be interesting to get to know our audience just a little bit, to understand from what angle you're coming and listening in. So who of you are independent freelancers working on your own product or for other companies to make your living? Or not, or not. Yeah, okay, so that's, I would say almost probably more than half of the room. How about, are any of you employed by a company and you have your daily routine with new exciting products by some of the bigger companies perhaps? Okay, that's a reasonable amount of folks.
So knowing that, Philipp, I think, and Francine, one of the biggest push-pulls in negotiations we get is when independent developers are asked to engage with larger companies and provide code and help develop products, and you are really worried. How many of you are worried about like reusing the code that you develop? We call that background IP. That's a huge topic, right? You want to retain your background IP, your basic code that you use and reuse, and you just want to make it customized for whoever's hiring you. Right, so that's a big topic. You want to say anything on that one, Philipp or Francine?
Yeah, I think that's always the biggest question, because all of you, I'm sure, you're creative, a creative group, a bit more creative than lawyers maybe even. And the biggest question is, for whom are you creating the code or the software that you're working on? And some of you may be employed by a larger company and you have some sort of a contract in place, and then you may be working separately on your own product. And the biggest question is of, ownership, who at the end of the day may do whatever they wish to do with the code you're working on. So in the past, we've done this panel too, and there were a bunch of questions about licensing options. What are your opportunities? What could you do? What should you think about? And we'd be happy to answer any of those questions, right?
Francine, you have any good suggestions when you're hiring third party? You probably do most of your development in-house.
Most of it, but we do also hire third parties to do it. And I think IP ownership for me is probably one of the biggest things that I'm looking at when we're talking about it, because yes, you've developed the code, but actually we as a company, we're engaging you and we want to be able to use it freely. We don't want someone to come after us and sue us for the fact we're using your code. We also might want to take your code, do something with it, and then go on to use it. And we need to have the right to be able to do that. So one of the key questions I'm always asking is, well, where has it come from? And do you, as the developer, do you have the right to give it to us? And that's one of the really big sticking points that we find in most negotiations. And that's often where Heather and Philip come in. Like, okay, well, let's sort out what you can do and what you can't do.
So it's a definitely resolvable issue. There's so many ways to slice and dice that. Since we only have 20 minutes, we won't go into too much detail, but usually it ends up getting carved out. Your background technology that you bring to the project, when we have to, we'll sometimes concede that you obviously get to keep that. Philip, you want to go into more? And then the custom work product is owned by the company for whom you're developing it for, and they might get exclusive rights to that in a certain field for a long time, something like that.
Yeah, and since we had a few people here working on their own products, I understand that agreements can be a little bit scary, but when you have people working with you on certain products, and I understand, and I have some engineer friends who start something cool with a friend, it makes sense to at least not down the expectation of each party, right? I understand, hiring a lawyer could be scary, it could be expensive, although we hope to make an impression that it's not too scary, and you're always welcome to reach out and to pick our brains on something. But it makes sense to maybe even knot down the few points as bullet points that you're expecting, right? Who should, at the end of the day, make the decision with whatever product you're working on? Who should be the owner of the product? And having thought about this at an earlier stage in time can maybe, help you a lot going forward.
Yeah, and the last thing on your checklist for you, all of you who are developers, when you use third-party IP incorporated in your product, you also have to think about what rights you have in giving that to another company. All right, that's probably it. Any other questions about that topic?
Yeah, I think that's, okay, there's someone over there.
Hello. Yeah. Whoa. How typical is it to encounter situations where maybe a contractor is developing something that's really exclusive, but in the course of that is actually finding something that would incorporate well into their base technology that to separate those things? Like, is it obviously someone like Focusrite, if you're hiring, you want the perpetual, irrevocable, potentially exclusive right, but if a contractor is developing something for that product that involves building some base technology that may be reusable, that isn't necessarily something Focusrite cares about from an exclusivity perspective, how is that something you have to navigate often, and how do you navigate that?
Francine and I have negotiated that. You want to speak to it, Francine?
Yeah, sure. We've negotiated. Heather's still alive, as you can see.
Barely. In fact, I'm going to stay a little farther away from you right now.
What I would say is that does sound like something that you do need to negotiate and probably carve it out or talk about an enhanced fee if you want to be able to sell that product on. So to the point Philip said earlier about agreements, so I love a good old 30, 40-page agreement setting out rights exactly like that. I appreciate you people might not want to read an agreement that long, which is why I would recommend you do hire a lawyer sort of early in the beginning so that we can negotiate and we can come to a fair position for both parties.
Right. I would say something to Francine like, Francine, our developer client really wants to work with you, is excited about developing this product for you, and they'll create these beautiful plugins, but they want to retain the right to reuse their background IP or base IP on other products. And you'll say something like, okay, but give us exclusivity, or, right, you can't do anything close, substantially similar to these products for X years, right? Something like that.
Yeah, that's generally where we get to.
And we have that all the time, actually, because a lot of companies, especially small companies, are working for other larger companies to get some income in while working on something exciting on their own to make it more lucrative on a long run, right? There's always this vision, either you team up with a large company or you get bought up by a large company, or you work on something while you make, you can make a living. And in that context, it's very important to define these expectations, and then also to define what will be reusable, right? What is subject to a non-exclusive license versus what will be exclusive, or what will be even, assigned to the the party that you're working for. And usually it's the individual, the customized things. Maybe you're working on a product, maybe there's a GUI involved even, but then the underlying technology could be interesting for other projects.
In 30 seconds, I'm going to tell you all the different ways you can negotiate a license agreement, and I welcome them to chime in. You have to decide first and foremost, do you want the money up front, or do you want to be more of a business partner and do a rev share? So that's the first thing you have to decide. Sometimes from large companies, possibly, I don't want to say Francine's company, you can get an advance.
Generally, we prefer it as you do it.
But sometimes one could, if you've got the leverage, you can get an advance to cover your engineering expenses. And then that could be a non-refundable advance against royalties. You can do a blanket fee for what you're doing, or most companies really do like it if you're going to be a true partner, not in a legal sense, but in a business sense, of doing a rev share and partnering with them, and based upon sales and how well it sells and things like that. Did I leave out any other? Is that all right? There's so many different ways to slice and dice these deals. Yeah?
Jeez. Yeah, as an employee working at a company, usually it's pretty standard, at least I feel like, in the contract that, you know, this company will own everything you produce.
Your life. They will own your life.
Exactly, pretty much.
Right.
So do you have any good advice when, working on something of your own on the side? Like, what's important to think about when to start? How do you approach that negotiation?
Right. If it's in this similar space, I know I'm jumping a little bit because we have so much to cover. You would go to Francine and you would say, Francine, you're really better off disclosing this. I've got a side project I want to work on. And in fact, probably your agreement requires them to disclose it if it overlaps with your business. Yep. And how will they do in negotiating with you to do a side project, Francine?
So I'd say it's not just a competing business, it's any business. We ask for people to tell us. The key is early dialogue, so come to tell us when you're thinking of setting it up, when you're getting started. Usually it's a discussion about sort of, one, how much of your time is it going to take? And how much of what you've learned at work are you sort of imparting into what you're doing? And really all we want to get to is a position that we know that you and I will never compete. And if we are going to compete, and it really is something that you're sort of working on that's really similar to your current employer, then really we're probably not going to have much of a negotiation. You're going to have to toe the line. But for everything else, I mean, generally employers are open and encourage creativity because you never know what benefit it can reap in the time.
And it also depends a little bit on where you're located and what laws are subject to your arrangement. So, I mean, right, Germany's slightly different than the UK, and the US may be different than the UK. So that is relevant too, but it doesn't really matter where you are. Disclosing it, coming to an agreement beforehand, being transparent at least to what you're doing can really, again, set the expectations, and you can then be more relaxed while you do it without coming up with crazy structures like backdating.
Yep, exactly. And if you get permission, if you get permission, which I hope you do, if you ask if it's really not competing with a business, you have to really be careful to do it on your own time, after hours, not during the normal workday. Do not use your company computer, and really keep separate what you're doing, because you always, even if you get permission and Francine finds out you're using Focusrite's IP, that's not going to be cool.
It's not.
So it's
be fun though.
And so yes means yes, so long as you follow the rules and really keep it separate. Yeah.
Cool. Thank you.
I missed the first.
Who wants to ask the next question? We can probably go over a few minutes.
I missed the first 30 seconds, so I'm sorry if this is redundant, but just for clarification, do you define IP as software having issued patents, or on the contrary, do you regard IP as just any art, whether one's disclosed it to the world or issued patents?
Oh,
and the reason why I ask is because some feel that patents, particularly in the software domain, are a liability and just a cookbook for poachers.
Great question. So your question is, I think, twofold, right? IP to us means trademark, copyrights, trade secrets, and patents. So that's your first thing. But if you're asking specifically, should you think about filing a patent because you have to disclose the invention? That is a question that so many people grapple with.
Well, Well, it's,
What's
it's the,
Focusrite
it's the
strategy on
conundrum of
this?
trade secret versus issued IP, and letting it essentially offering a cookbook to would-be competitors and poachers.
A strong patent is very valuable in building your IP portfolio. If you're thinking about building a company and selling it, if you really have a good patent, that will be worth probably more money to your company and give you a chance to protect it. Trade secrets is a very valid form of protection if you're worried about disclosing the invention, but you have to be meticulous with non-disclosure agreements. Anyone else?
Yeah, by default, the most obvious one of intellectual property is copyright. And as the author, you start off as you are the author and you have the rights on how you're going to license this away. But of course, it's difficult to prove sometimes, right? Where are you coming from and where are you getting it to? So whenever you do share your source code, if you share it, make sure to have a non-disclosure agreement in place to protect your trade secrets, and to also have maybe some sort of have a license agreement in place that really explains what the licensee may do with the code and may not do with the code. But these are the more obvious protections.
At least in the US, one way to kind of hedge your bet on this is to do a provisional patent, which is just a few paragraph description, and then decide whether you want to go on to a full-on patent. Just one suggestion. Anything on that lovely patent? How many patents does Focusrite have?
Not that many, because one, they're very expensive to register. There are corporation tax benefits in some jurisdictions to having patents, but I think the moment you do register a patent, you have to be aware that obviously it is out there, and you then have to have the heart to defend your patent and go after people.
Patent litigation is $2 million on average in the US.
That's minimum if you're lucky.
Right.
And if you're going up against IBM, you could be in court for 20 years. Because they'll just keep on going and going and going. And so
It's
that's
just
a formidable liability, it would seem.
from, just from my love of the audio industry, which I love, I do appreciate there's not a lot of patents out here. There are patent trolls that have been going after some of our clients, but it's not really on the core audio concepts. It's more on like copy protection and things like that. So personally, I would prefer not to have a lot of patents in our industry because I think they can be used to sort of control, monopoly, but I don't want to say too much more because it's being recorded. So I like whatever my clients want to do. So if they can get a great patent, go do it and sue everyone, right? All right. I don't know, Phil, help me here. All right.
Yeah, online questions.
Oh,
Yeah, so we have 12 more minutes. Is that right?
wow, we've covered a lot. Anything here we want to talk about? Okay,
Yeah, and
hot topics. Do you want to know hot topics right now? Privacy. How many of you release products right now that collect personally identifiable information? That can be anything, including email addresses, right? Philip just got certified as a privacy specialist.
Yes, and
Let's go, Philip.
thank you. At some point I went ahead, and so we've been advising in this. I think the first project I ever did for Heather was in 2012 when the GDPR, the General Data Protection Regulation, was just announced, and that was my first, my feedback from the European continent to the U.S. and where in the U.S.
So
nobody knew what.
complicated, right? California, we have a new legislation coming
it's
out, the GDPR.
Well, we have the CCPA, the CPRA, which amends the CCPA in California. We have a bunch of other
UK
states.
has its own rules, right?
Slightly, well, it's like an interpretation of the GDPR. You can chime in about that, but I mean, they all go to the same principles, right? It's about transparency. It's about giving the choices and the options to the end users, about personal data, right? So it's beyond just So we can discuss it more, but it's very relevant when you also marketing newsletters, tracking your users. And I always say the easy way is to be transparent and giving choice in certain instances, and we have to assess each scenario individually. So it's very difficult to give you one.
Our clients get so frustrated. We want a privacy policy. Can you have it to us in an hour? We're like, well, it doesn't work that way. You just can't take someone else's privacy policy.
Oh, And the issue is, that's actually a big one, because I know a lot of indie developers, release their product and then they go online and there are all these templates available that you can just download. There are these privacy policy generators, right, where you can just fill in some of that information. The issue with that is they sometimes include much more information than you actually need and want to disclose. Because the biggest issue that you have with privacy policies or any of these promises that you make to your customers, if you provide something that is simply inaccurate, if it's incorrect. And we've seen privacy policies from companies and clients that were also generated that way in the beginning. Obviously, they have been changed over time, where they were making promises or maybe even going beyond what they need to do. And then you could even get into problems with the Federal Trade Commission, with the FTC, because if you're doing misleading information, then that's not the way to go either. So yeah, it makes sense to at least have an expert give you some sort of guidance on what these things actually mean, to not over-promise.
But our job is to, as lawyers, is to help you. Many of you, if you're doing a partnership type deal, you want to know how many people are actually maybe downloading your product, or, well, you'll know that. You'll want to share data with your partner and how to do that, right? And
I understand you want to understand your audience. It makes a lot of sense. And the audience actually wants to be understood too, because they want your product to be more along the lines of right? So it's not one-sided, but figuring this concept out in a compliant way will also be very important when, for example, you're licensing or selling maybe even your product to a larger company. It's a part of the due diligence checklist.
Yeah, collecting data in our industry and all in tech industries is so important and very helpful to you, but you have to do it right because the governmental authorities are very much cracking down on this. Anything else, Ms. Francine?
What I would say from your point of view is when you're thinking of your privacy policy, think about how you'd like your data to be treated and what you'd like to happen to it, because that's a really good starting point for anyone's privacy policy.
Okay. Where are the online questions, or should we?
Yeah, right here. We have a couple. The first one is from an anonymous attendee. I'm very curious to hear about the status of copyright with regards to machine learning model inputs like DALL-E and Stable Diffusion.
Right. This is such an enormous topic. And in fact, we were just communicating with our team in the US who has an article that we're polishing up on this. Anyone want to do a one-sentence summary of where we stand on this?
Their final question was current state of the law. They want to know the current state of the law. Just want to finish their question.
All right, it really...
Did they specify the country?
Yeah. So
they did not.
The complexity is, right, machines can't have copyright ownership. So, right, that's easy. So it's the people, it's the company that are gathering the data. The problem is where you get the data from, where you're scraping the data from. And so an argument could be made, for example, if you're studying, these data sets are huge. Anyone do this kind of data scraping in AI, right, in the audience? Like, the data sets are enormous. Are you taking it from all these songs out there that you don't really have the rights to? What part are you taking from the songs to analyze them? As a music example, is such a huge topic. So I suggest that we make available this article we're polishing up right now on this topic.
We will do that, certainly. And there was last year at ADC, I think, Heather, you had
you're right. Thank you very much.
Wonderful panel that you've moderated.
Thank you, Philip. Yes, we did a panel with Descript, which does a lot of the deepfake technology, enables it, but tries to legally make sure they're our client, that it's being used in an authorized way where you can create anyone's voice, for example. So anyway, we had, they were on the panel.
So that YouTube,
Sonable, is anyone here from
video.
Sonable, which worked with you on the fast plugins? And we had two other people, a journalist, Chris Cook, who's also a lawyer, and Bobby Lombardi. And so it's online, and take a look at that and reach out with more questions.
But I would summarize it maybe in one sentence. The laws have not changed because of artificial intelligence. We're still using the same structure, the same copyright law to understand the mechanism. And the issue is a little bit above just figuring out from a copyright perspective, because again, machines cannot hold or own a copyright. So that is one angle of it. But then again, the bigger issue is, where are you getting that information from? And that could be subject to different rules even, right? To even contract law, right? You have license agreements that specifically explain you what you may do and what you may not do with that set of data. And maybe they haven't thought about it, that it's going to be used for artificial intelligence purposes or machine learning purposes. So that's a bit of the issue. So it's a new landscape. It's a changing landscape, also from a legal perspective. And from a legal perspective, you'll probably hear more and more from courts where this has become an issue. And we'll stay tuned and we'll keep
We're
you
going to pitch a
updated.
panel. Jay said he's happy to come back. They're doing a lot more with AI Descript. We'll try to resurrect a panel, and if all of you vote for it, we'll do a great panel on this next year. And in the meantime, just give us your information. We'll send you the article we're preparing.
Thank you. Do we have time for one more online question? Or okay. As a contractor, should you accept it when the client expects to be indemnified against your work, accidentally infringing any patents?
I'm laughing because these are the biggest topics of all time.
Right, so indemnification. I understand that you're that individual, maybe not even set up your company, and you are now assigning, or you're working for a bigger company, and they have these very one-sided, representation of warranties clauses, indemnification clauses. Not all countries, when you're dealing with someone fair like Francine, could be a different story, but and then you sign these things, and it makes sense to, of course, limit your liabilities to that extent, to at least, to make sure to maybe only...
You can give in an indemnity, but limit your liability.
Yeah.
That's kind of this is a really fast primer we're giving you right now.
Yeah, you can cap your liability, and you can also reduce it to only willing or, knowingly infringements to then...
15 seconds.
carve out.
Francine, I'm sorry, but you're the wealthy company, and I'm a poor developer, and I really cannot agree to $1 million limitation of liability. To the best of my knowledge, my code is clean, but how do I know? There's patents out there. There's a landmine, Francine. You can't make us responsible.
I can. So, Philip, I hate to contradict you when you say unfair. No, absolutely. As your contracting party, it's absolutely reasonable to want an indemnity and to have an indemnity. You have the option of doing your research and making sure that your work is as robust as you say it is. I expect you to be able to stand behind your work, but you also have the option of taking insurance out. And as a reasonable contractor, I'd expect you to do that as well.
But insurance is so expensive. We're a small company, and we don't know about these patents, Francine. Can't we compromise and agree?
We can limit liability, I agree, but I do expect you to be able to stand behind what you're providing to us.
And that's where you're going to want a lawyer to fight for you. Can we take a question from Henry?
Really quick one. Do I need a bit for the on-marks? Thanks. It's just kind of on the back of that. Lawyers cost money, and a lot of people don't have a lot of money when they're developing and starting out. What do you say to those people who should have legal assistance but can't afford it, and what can they do to get the funds to get that, or what can you do to help those people?
We try to be very flexible. The industry has been very good to our law firm, and we have some larger clients who that's less of a constraint. So we try to, not everyone in the firm agrees with Philip and my philosophy, but we really try to work with startups and be very upfront and say, can you come up with this amount? And we will work with you in the beginning. And please remember us when you're wildly successful.
Yes, that's one thing, and we'll also help our client who have a limited budget to prioritize, because we understand if you look at that list, I'm very happy that not everybody just ran out and was hiding back like, I don't actually want to have anything to do with this, but we'll help you prioritize on those items that may be very, a first priority, and then we can look at these other things that would be good to have, important to have, but maybe not need to be done yesterday.
The most important thing is clean IP. Really, I cannot stress that enough. You need to know who owns your intellectual property, and you need to own it, and you need to make sure if you use third-party elements that you have a right to do it. That's the number one, maybe mistake. And then complicated investors, equity issues, but we don't have time to go into all of this.
I think also we only have one more minute. Do we have time for one more question?
Can we go a few minutes late since we're going to lunch? Thank you. Applause to Sophie, by the way, for... Okay.
So this gentleman asks a critical question, and you mentioned that sorting is an important aspect. So rather than getting 100 emails with the same question, has your firm published a PDF or something online that says, for situations where you're starting out and funds may be limited, here are 1 or 2 recommendations where we take this 20-point bullet list and have sorted it for you from top to bottom in terms of the priorities you should consider.
Yes, there
You
is
have
a
that?
panel at 5 o'clock. Is it 5 o'clock today for startup companies? And we're going to go over that. And we have an hour for that. So great question. And thank you for letting me promote that. That's, I think, at 5? Does anyone know? Sophie just left. Yeah. I think it's at 5. When is the startup panel? Sophie, do you remember? Our startup panel. I think it's upstairs.
3 o'clock.
Oh, okay.
There
3
you go.
o'clock. Thank you. I'll be there.
All right.
Come on, ask Francine a really hard question. It's her turn.
If I'm a developer and I have the product doesn't have necessarily like novel technology in it, but the assemble of the simple ideas is a novel idea, and I'm hiring independent contractors, what are some of the guardrails or expectations in a relationship like that? So
you
like, what
understand
would
that?
the structure of that relationship look like?
I think we missed the first part of
Are
the
you
question.
saying you're hiring the developers?
Yeah, if I'm a
Right.
small production company, a
Okay.
small like technology company, and I'm hiring independent contractors to design a product, it's not necessarily novel ideas, but the assembly of the simple ideas is a novel product. So what are the guardrails? What are like the liabilities? What would a independent contractor be asking for? What's like right or what's just in a relationship like that?
It goes a little bit back to the earlier question. One is compensation, right? Well, how are you going to pay the contractor? Are you going to pay them up front with an advance? Are you right?
Yeah,
All
if it's
these questions.
fairly upfront.
Yeah.
Or,
Exclusivity, this, that, yeah.
Yeah. And then the second question, how you know, who has what sort of liabilities in if something actually goes wrong? And that's the other side that can be negotiated. It's difficult to now give an answer for best practice because it really depends on the scenario. It depends on the deliverables of what you're providing, right? Is it only something that you're designing? Are you using third-party libraries? I think it really depends on the scenario. Is that?
Yeah. And then one topic we didn't touch upon, which just popped into my brain, really a big issue that things get stuck on, is testing acceptance criteria and what to do if Focusrite's not happy with the product you deliver. There's so many topics we could cover right now.
And
right?
it is one of the biggest questions. The most, you know, you can have a great long agreement with the fantastic limitation of liability clause, and then at the end of the day, it all goes down to one thing, and it's the money. It's like, why am I not getting paid now? Well, I'm not happy as the licensee. I'm not happy with what you've built for me. So please continue. And here you're sitting, you know, weeks after weeks after weeks, and you agreed on a flat rate. That is an issue that we sometimes have as lawyers as well. But you. But yes.
It's been such a pleasure.
Thank you.
Next slide, if we can show the next slide and people want to take a picture.
Oh, yes. Yeah. Yep,
We
yep,
don't
yep.
have Francine. Francine, are you going to give your email?
No.
We
No?
can.
All right, if any of you need an inside to Francine, reach out
Yeah.
to me
Yeah, go
or
to
Philip.
Yes. Yeah, so
Thank
we
you.
always welcome, you know, we can speak more, and there will be no charges in the beginning.
Thank you.